So I'm going to be talking to you about wills this afternoon, and Sophie will then do a talk about powers of attorney. Okay. So we're from Lodders Solicitors. We have 4 offices in Stratford-upon-Avon, Henley, Birmingham and Cheltenham. And the 3 of us specialise in the private client area of law, so we deal with wills, powers of attorney, trusts, estates and tax advice. So first of all, I'm going to be talking to you about wills and why these are so important, and also why it's important for them to be kept up to date. So the main problems that we encounter when dealing with people's estates is either somebody hasn't left a will at all, or they've not had the proper advice and their will doesn't fit the circumstances that they expected. It's very important to not only make a will, but to keep it up to date. So as your circumstances change or the law might change, it's just keeping in touch with your solicitor to make sure that the will fits what you need it to. So at the moment, it's estimated that 2/3 of the adult population don't actually have a will. A lot of people obviously are concerned about making wills. Obviously, sometimes people don't have the time to do it. They think their estate doesn't warrant a will, or they think it will cost too much to take advice and to actually do a will. Also, we don't want to contemplate our own mortality and think about what's going to happen when we're not here. But from the case studies that I'm going to talk to you about, you'll see why it is important not only to have a will, but to keep it up to date. So the first case study relates to a gentleman that didn't have a will. So we have John. He's a single man in his 30s and no children. So he owns a home without a mortgage, and the property's worth about £250,000. He's also got some savings of £50,000. So John died without a will. He had a car accident, and his estate was then dealt with by the rules of intestacy. So when somebody doesn't have a will, that's when the law makes assumptions about how your estate is distributed. Unfortunately, it doesn't always do what you think it might do. So in John's case, his estate would go to his parents in equal shares. Unfortunately, his mother died before him, so his whole estate would go to his father. In this case, John's parents had divorced when he was young, and he didn't have a relationship with his father, and so it ended up that a £300,000 estate went to John's father under the rules of intestacy rather than going to the beneficiaries that he would have wanted. It's also important to note that the rules of intestacy don't make provision for partners, so for common law partners. So if John had a partner, then they wouldn't have been included in the rules of intestacy. So the next case study relates to a lady who did a homemade will. So Susan prepared a will in respect of her 2 properties and her cash assets. So her first property she gave to Mr. and Mrs. X and to Mr. and Mrs. Y in equal shares. She also left to those 2 couples her bank accounts. She did have a second property of which she owned half. The other half was owned by Mrs. Z. Now, under her will, Susan stated that property 2 was to go 50% to Mr. and Mrs. X and also Mr. and Mrs. Y in equal shares. The other 50% was to go to Mrs. Z. But what she didn't realise was that only 50% of her property would actually come under her will. So she actually didn't intend for Mrs. Z to get her half of Susan's half of the property. Okay. Also, Susan did have some investments, but because she didn't specifically gift those or leave a catch-all provision to pick up any other assets, that part of her estate didn't fall under the will. That fell under the rules of intestacy. So you end up with a partial intestacy in that estate. And then the third case study relates to a lady who did make a will but didn't keep it up to date. So Margaret made a will in 1982 with her solicitor, And when she died in 2016, it hadn't been reviewed or updated. Unfortunately, the executor had died in Margaret's lifetime. So what happens then is the beneficiaries are responsible for administering the estate. So the main beneficiaries were her children who didn't get along. So then they're responsible for dealing with the estate and making sure it's distributed. Margaret did leave some cash legacies to her grandchildren, and she named them specifically. Unfortunately, a grandchild was born after the date of the will, and so technically under the will, they wouldn't get that cash legacy. Some of the children did agree for this grandchild to actually have the cash legacy, but as there wasn't a unanimous agreement, the grandchild missed out. So had Margaret updated her will, there could have been things picked up to deal with a new executor, new grandchildren. So when you take some advice on your will and estate planning, it's important that you obviously consider things like inheritance tax, what might happen to any assets that don't fall under the will. So there might be assets in trust, there might be pensions, insurance policies that actually fall outside your estate. So a solicitor can advise you on that as well and where you stand in relation to the will. If you have any foreign assets, it's important to discuss those as well to see whether they should be included in the UK will or if a will should be done in the country where that asset is. So it's quite easy to put off doing a will or updating it, but it's always worth just keeping in mind any change in circumstances. There's often changes in the law, particularly about inheritance tax. So it's always worth just keeping things under review because things might actually be a little bit more complicated than you think and you might need more in-depth advice or just a review. Okay. Obviously with these examples, where you don't have a valid will, it not only incurs more cost to deal with during the estate, but it's very distressing for the families as well when things aren't as they thought they would be. Okay. So that's just a review about wills, and Sophie's going to talk to you about powers of attorney.
I'm not going to launch into any Britney Spears for you, don't worry. Now, as Jess said, I'm going to talk about powers of attorney. There's lots of abbreviations that I will be using when talking about powers of attorney, because otherwise I'll be here for an extra half hour getting all the words out. So lasting powers of attorney will be LPAs, enduring powers of attorney, EPAs, and the Office of the Public Guardian, OPG. Okay, so otherwise, honestly, I start to trip over my tongue. So here we go, starting with LPAs, we ask the big question. If you couldn't make your own decisions anymore, what would happen? Who would make those decisions for you? And there's often a misconception that if you have a spouse or a civil partner, or even someone that you've named as your next of kin, those people will have an automatic right to make decisions for you about finances and about health and welfare if you lack the capacity to make those decisions yourself. And that's not the case. There is no automatic right that passes to any of the people who are close to you. And in fact, next of kin, whilst it's a phrase that you will have heard a lot, and when you go into hospital, you may be asked to name next of kin, in reality, in legal terms, it means nothing. There is no legal standing to that. It's normally just an in case of emergency contact. So what you really do need to do, whilst you are able to do so, is think about who you would trust to make decisions for you in circumstances where you're unable to make those decisions yourself. And the system that we have in place at the moment is twofold. I've got my two roads going off in slightly different directions. We have the power of attorney side of things and the court of protection. Now, under the power of attorney side of things, we have EPAs, which were the documents that you would prepare, I think, between 1985 and 2007, if you wanted to appoint somebody to make financial decisions for you. They were very straightforward, very easy to get hold of, generally only 4 pages long, and were quite often done by people as an add-on after doing a will. The solicitor would say, for another 40 quid, let's do your EPA, and people go, okay, because it was nice and straightforward. Unfortunately, because they were so straightforward, and human nature being what it is, there were a lot of attorneys out there acting under EPAs who took advantage. So the system was tightened up, rules strengthened, supervision put in place, and we have LPAs now. So from 2007, if you've wanted to appoint an attorney to make financial decisions for you, or, and this is a slightly new element, to make health and welfare decisions for you, you will be preparing an LPA. If you have an EPA in place and you are happy with the attorney that's nominated, you don't need to change it, it is still valid. But if you wanted to amend it, if you wanted to make it perhaps more flexible or appoint a replacement attorney, you would need to look at doing a Property and Financial Affairs LPA. Both EPAs and LPAs give you the ability to appoint people that you trust to make decisions for you if you lose capacity. The tightening up of the system regarding LPAs means that the documents, well, all the power of attorney documents need to be registered before they could be used, or should be registered before they're used. And this is where the problem with EPAs came in. The documents functioned as an ordinary power of attorney prior to registration, and then if you as the donor lost capacity, your attorney was meant to register the EPA with the Office of the Public Guardian. But there was nobody overseeing the process there to make sure that that happened. So attorneys were relying on unregistered EPAs and continuing to do things that they shouldn't do, with nobody having any oversight and stepping in to stop them. With LPAs, what has developed is the forms get registered once everybody's signed them. That activates the document, so it's ready to be used, and the registration of the LPA has no comment to make on your capacity. It's not triggered by your incapacity, it's just an activation to make sure that the document is there, ready to be used should it need to be. And then the Office of the Public Guardian is aware that the document exists and can oversee what the attorneys are doing if they need to, can intervene, can investigate, and can remove attorneys if there are any concerns about what the attorneys are doing. So there's a little bit more oversight there than there was. Now, if you haven't got an EPA or an LPA, and somebody close to you wants to be accessing bank accounts, for example, they can apply to the Court of Protection. So there is a way to get involved if an EPA or LPA isn't in place. They can apply to be appointed as a Property and Financial Affairs Deputy, and the system works, but it works slowly. It's not a quick process to go through, and it costs more than preparing an LPA would. You then have a court application fee to pay, and then there's ongoing involvement from the Office of the Public Guardian, who will charge an annual admin fee. You have to pay an insurance bond, and you have to submit an annual report to the Office of the Public Guardian as well. So there's a bit more responsibility on the face of it, a bit more paperwork, a bit more red tape to hop through for a deputy. So it's useful to have that facility to be appointed as a deputy, but it's much better for you to decide who you would trust to decide things for you if you couldn't, and to go through the process of preparing a power of attorney document, setting that out. The other thing about deputies is if nobody within the family is willing to take it on, or if there isn't anybody suitable, you can end up with someone like me, an independent professional, making your financial decisions for you, which is all well and good on one hand, but I don't know you at all. So am I going to really be able to make the same sort of decisions that somebody who was close to you and knew you would? I can be logical about it, but I don't really know what charities you might have supported or what investment strategies you would prefer. Now, LPAs, I said there are two types of LPA now. The Property and Financial Affairs LPA will enable you to select an attorney, and that attorney or attorneys will be able to buy or sell property for you. They'll be able to open and close bank accounts, claim state benefits, deal with pension providers, talk to HMRC about your tax affairs, pay bills and outgoings, deal with general investments, savings, and they will be able to make limited gifts on your behalf. And that is an important point both for you to understand and for attorneys to understand, because even if you've been in the habit of making inheritance tax efficient gifts of £3,000 a year, your attorneys can't carry that on for you without the authority of the Court of Protection. Attorneys can only make reasonable gifts on occasions such as birthdays and Christmas, things like that, so they can't continue a pattern of tax efficient gifting for you. That's kind of, again, human nature being what it is. There have been cases, you see, where attorneys have seen fit to really benefit themselves with some generous gifts that they just know you would have wanted them to have, like, you know, a new car and some designer handbags. But to kind of really avoid that sort of situation arising, it's hammered home in the LPA document itself. Attorneys really have very, very limited powers to make gifts. The health and welfare LPAs look very similar, but clearly deal with much more personal things, I think, much more personal decisions. Things like where you should live, what care you should have, you know, organising assessments for social care and support, what activities you might enjoy taking part in. Do you want a cup of tea at this time of day or not? What clothes would you like to wear? Dealing with your correspondence, and then really, really fundamentally, you can give your attorneys the authority to give or refuse consent to life-sustaining treatment on your behalf. Now, for most people, when you say life-sustaining treatment, they're immediately thinking about resuscitation, end-of-life care, withdrawal of life support and that kind of thing. But of course, life-sustaining treatment can, in certain circumstances, be a course of antibiotics. If you have a serious infection and you don't have it treated and develop sepsis, you will die. And there's no handy legal definition, of course, of what life-sustaining treatment is. So I think when you are thinking about appointing a health and welfare attorney, it needs to be somebody who you not only trust to make the right sort of decisions for you, which means they have to know you, you have to feel comfortable having these discussions with them about what you would and would not find acceptable in terms of your own quality of life and the interventions that you would or wouldn't want to have. So it's not the sort of thing where you'd actually want a professional attorney involved. Again, when it comes to finances, sometimes we will be appointed as attorneys if people don't have anybody else. But with health and welfare, you really do need people who know you and who you can have these frank discussions with about what you would or would not want to happen in certain circumstances. Not always the happiest discussions, but really, really important. So I've got William. He's a 50-year-old married father of 3, and of course things aren't going to go well, are they? Because this would be a really rubbish case study if everything was then fine. He's going to have a serious brain injury following a car accident. Now, when he is immediately in hospital, you know, in the aftermath of the accident, it becomes apparent to his wife that they hadn't considered who can deal with his business. Because he's a sole trader, he's the one authorised to access the bank accounts, he's the one who's entered into all the contracts and agreements, he's the one responsible for paying salary to a couple of employees there, and his wife isn't allowed to access the accounts. The bank, bless them, might want to be helpful, but if you haven't got that piece of paper with giving you the legal authority, they're not just going to be flexible on this one occasion and let you do it. So all sorts of problems could crop up with the day-to-day running of the business, and sadly William might find himself sued on various incomplete contracts. So what he needed to think about is not just perhaps having a power of attorney in place to appoint someone to deal with his personal things, but also his business side of stuff. Now, it might not be his wife that would take that on, but maybe he does have a colleague or someone who works closely with him who would be the ideal person just to ensure some business continuity in the event of something bad happening. Now, William also has a number of sole name investments and savings accounts. Initially, things aren't a problem for his wife. They have a joint account. She's able to continue to use that. The mortgage is still being paid, but William has been in the habit of topping up the joint account from his sole name accounts. The same problem arises with her trying to access his sole name accounts with the bank. The fact that she is his wife carries no weight with them. We're not talking about the days where you used to have a relationship with your bank manager and could go in and ask for some understanding and a favour. If you can't get through the little boxes on the front screen of the machine, then it's a no. So there are going to be difficulties there. She can apply to the Court of Protection to be appointed as William's deputy, and she can even ask for an urgent interim order to give her access to specified accounts. But even when we're talking about an urgent interim order, it might be a couple of months. And what's urgent to William's wife is not always on the same level as what's urgent to the Court of Protection, who are dealing with cases about withdrawing life support from terminally ill children. So there's a scale of things there to deal with. Following his accident, William also needs full-time care. Now, initially on his discharge from hospital, the medical staff have identified a rehabilitation hospital that they would like him to go to. And on the face of it, there's no problem with that, except William's wife knows that William wouldn't want to go to that particular rehab hospital because it's where his mother was and she had some terrible experiences. See, there's a slight disagreement there between the medics and the family. Now, the medics will often listen to what's being said, but maybe there aren't many other options, and if they deem it to be in William's best interests, he will go to that rehab hospital, even if his wife's saying he really wouldn't want to if he could make that decision himself. If she was his health and welfare attorney, she would have a more overriding authority to make that decision for him. So you can see how these things can crop up in unexpected ways. My final thoughts, it gets a bit philosophical on the final thoughts. But you've got an opportunity to set things up now with the systems we have to make sure that people who you really do trust to make the right decisions for you are in place to do that. It's better than leaving it to fate and to strangers. Take that positive step to think about it and have those awkward discussions, and then have a gin afterwards. It's fine. Get it out of the way. And as Confucius says, I've quoted him on the end of the slide here, and who am I to argue? A man or woman who does not think and plan long ahead will find trouble right at his door. So you do have to look forward and think about these things. None of us are immortal. We will all need a will one day. Whether we will need a power of attorney is a moot point. We can hope not, but let's have it. We have house insurance. Let's take that insurance policy of having an attorney in place.